Hello and a warm welcome to Federal Special Program Capital Beat. President Droupadi Murmu's decision to seek the Supreme Court's advisory opinion on critical constitutional questions marks a rare and significant moment in India's constitutional jurisprudence. Now, the reference made under Article 143 of the Constitution, which is the Supreme Court's advisory jurisdiction, seeks to clarify the legal framework surrounding the timelines and powers of the president and the governors when deciding on state bills reserved for assent. Now, the development follows the Supreme Court's April 8th judgment, which prescribed specific timelines within which the president and governors must act on such bills. And notably, Vice President Gupta criticized judiciary for acting as a super parliament in the wake of this judgment, which fixed timelines for the president to decide on state bills referred to by the governor for consent within 3 months. Now, President Murmu's reference has sparked a renewed discussion on the delicate balance between the executive discretionary powers and the imperatives of timely governance within India's federal framework, even as the questions raised by the president touch upon the complex issues of federal balance, executive discretion, and judicial review, which are areas, of course, that have remained contentious over decades. So, are these questions posed by the President of India opened a Pandora's box? Now, I was looking at this list of 14 questions which President Murmu has posed to the Supreme Court. Here you can see in this story, and through a proper graphics as to what all are those questions which have been posed by Droupadi Murmu. I'll just list a few of them. Say, for example, what are the constitutional options before a governor when a bill is presented to him under Article 200? She's made a mention of Article 200. Then similarly, few other questions like, in view of Article 145.3, is it not mandatory for any bench of Supreme Court to first decide whether the question involved in the proceedings before it is of such nature which involves substantial questions of law as to the interpretation of Constitution, and to refer it to a bench of minimum 5 judges? Now, this particular poser of questions has come on a day when Justice B.R. Gavai took oath of office as the Chief Justice of India. So, is this now a big challenge before the new CJI? Joining me now is retired Supreme Court Judge Justice Deepak Gupta, joins us this evening. So, thank you so much for joining. And always a pleasure having you on the program. And my first question, sir, to you is that do you see this particular incident where President Murmu has posed 14 questions? Is it some kind of a departure as far as the constitutional jurisprudence is concerned?
No, I don't think it's a departure. You know, it's a jurisdiction not exercised very often.
Okay.
But the government has the right. Article 143 of the Constitution says that the president can seek the advisory jurisdiction of the Supreme Court. Just remember that it is advisory. It is not binding. It's not like a judgment. It's an advice. So the president may or may not accept the advice. That's one aspect I would like to make it clear. It's been exercised earlier also. 143 is not exercised very often, but it is exercised, so I won't say. And I think this is the case where in fact, I was thinking of it a long time that it should have come earlier than later. You see, President Murmu, with all due respect to her, also acts on the aid and advice of the government.
True.
And when this decision came in this, just one. When this decision came in this matter regarding the Tamil Nadu governor, so Justice Pardiwala's judgment lays down certain timelines. Obviously, the government was not too happy with the judgment. But the questions posed, some of them I think are easy to answer. Some may pose a difficulty. And you said something about Constitution Bench. I didn't see that question. I don't know where. Maybe I missed it out.
No, this was, I think, question number 12. If you look at question number 12, it talks about that. I'm just going to read it out for the viewers.
Yes, I've got it. Whether it should go to 5 judges.
Yeah.
No, I've got it. I also just took out the printout a few minutes back. That's why.
Okay.
See, Coming back to the issue, when a constitution was drafted, nobody thought that governors, the high post that they hold, would act in a partisan manner. But unfortunately, now we see governors acting in a very partisan manner, not once, but the Supreme Court has held it on 2-3 occasions. This is not the first occasion that the governors are acting almost as politicians and blocking. See, we must remember that we are in a democracy. The central government, and we are a federal democracy. The state government may be run by a party which is not in power in the center, but the governor is appointed by the party in power in the center. But that does not mean that the governor has to act as a roadblock. Now let's come to the first question about 200, Article 200. When a bill is passed by a house, state assembly, or where there are legislative council, both the houses, then the governor has 3 options. The first option is to give his assent. The second option is to withhold his assent and say, I don't assent. But when he says, I don't assent to it, he must give reasons and send it back to the legislature that these are my views. What do you have to say? And the third is he refers it to the president of. But please see that the third exercise is to be done only in very peculiar circumstances. He can't refer every bill to the president. It's only when he feels that the powers of the High Court will be taken away or it will affect some central government powers that he can do it. And then he must give reasons. Now, if you come to the second part of Article 200, it says that because when he assents, then obviously there's no delay. The words used are as soon as possible. I'll just read it.
Yeah.
Provided that the governor may, as soon as possible after the presentation to him of the bill for an assent, return the bill if it is not a money bill, together with a message requesting that the house or houses. So he can send his message that this is the reason why I have withheld assent. Now, when it says soon as possible, it doesn't mean that the governor can sit over the bill for 2 years or 3 years, and that's what the judgment says. So I think as far as this portion of the judgment is concerned, at least I don't feel any need, And what are the constitutional options? These are the constitutional.
Right. No, but Justice Gupta, why do people attribute judicial overreach as well? Since the time
I'll come. Normally, courts have been very reticent to give directions to governors, keeping in view the high office which they hold, or to the president. Now, as far as in this case was concerned, I think the court was very fully justified in saying that the governor could not have sat on the bills for so long, and was fully justified in even laying a timeline for the governor. Now, the question which can be argued and which is going to be argued is, can there be a deadline of 90 days or 60 days or 30 days for the governor or the president to act? You see, can the court lay down a guideline which is not there in the constitution? And this point will have to. But at the same time, you can't lose sight of the fact as soon as possible. So
True.
I think maybe in each case, as soon as can be, a different situation. Let's take a situation where the governor is unwell for 2 months.
True.
There can be situations like that. Whether the question which will arise, and which is going to be an interesting question, whether the court could have laid down the timelines which are not there in the constitution. And there I think maybe the court, in my view, court overstepped a bit. The court could have said, yes, I'm totally in agreement with the judgment that the action of the governor was, in fact, mala fide. I would go to the extent of saying it was mala fide in not giving assent to the bill. And then the minute when they go to court, he sends them to the honorable president without seeing whether they need to be sent to the president or not.
But
So
Justice
it was
Gupta, another thing. There's another thing which people are saying that, okay, it was okay for the courts to order the governors because there were many instances where the governors sat over the bill. But to tell the president was a little of a transgression. That's
I,
what
I,
people are also saying.
I would also, no, I am not saying, I said, according to me, the question did not arise in the case. See,
All right.
that was not a question which arose in that case. And therefore, whether the court should have embarked on that, I would have been, if I was sitting on the bench, I would not have gone into something. In fact, the president was not before them.
Right.
The Union of India may have been there in a different capacity, but this question, I don't even know whether it was seriously argued before, because it did not arise in that case. Because in that case, there was nobody had argued that the president is sitting over the bill.
Right.
See, I would,
but
and
would you call this-
there's a difference, Nilu. I just going through, we're all students of law, and I realized that whereas these words are there for the governor as soon as possible, when it comes to the president, these words are missing.
No, but would you say that this was a shortcoming in the case, of Tamil Nadu case, that, this bit did not come up, and now that President Murmu has pointed out these posers, it's like opened a Pandora's box. Is it something which we are stepping
Well,
into?
I wouldn't call it a Pandora's box because it's a legal issue, and I would hesitate to give such strong directions that decide it within 20 days, 30 days. I mean, sometimes it's not possible. But at the same time, I will hold. I mean, there are other questions that is it justiciable? I feel it's justiciable. The court can sit into the question as to whether the governor is sitting over the bill unnecessarily or has he a reason to sit over the bill. I can put it to you. Let's say, supposing a governor writes back within 3-4 days, see, I have these doubts about the bill. Please clarify my doubts.
Yeah.
And there's no response from the state government. Then he's not sitting over the bill. But if the state government responds within 4-5 days and says, Your Excellency, these are your doubts, but according to us, this is the position, then he must. You see, we must remember we are in a democracy. Now, the state legislature represents the people. They pass a law. That is the will of the people. If they pass the law, now the governor must give assent to, or if he does, you see, he has even the power to withhold it. But then he must, as soon as possible, tell them, this is the reason why I'm withholding assent and go. See, the problem is, why the governor was not doing that, because once it goes back and the second time is passed by the assembly, then the governor cannot withhold assent. Now, can you imagine a situation where the bill is passed for the second time and the governor sits over it? Then I would say even 3 months is too much time. Then even a week is more than sufficient time for him to sign the assent, the papers for assenting to the bill. So each will depend on the facts of each case. I still feel that the court's judgment is absolutely right, but probably it overstepped into this little extent of, fixing timelines. I think that could have been avoided.
I would want to take up a few more questions. Like, say, for example, question number 10, Justice Gupta, it talks about the fact that can the exercise of constitutional powers and orders of the president and the governor be substituted in any manner under Article 142? Now, is that also a question which now the court will...
142 is the residuary power of the Supreme Court, which says to do justice between parties, it can pass any order. Now, why the need arose in this case was there were 10 bills which had wrongly been sent to the president.
Yes.
Because the court has held that either you assent, either you say, no, I'm not assenting, send it back, or you send it to the president. You can't first say no, and then send it to the president in a later stage. So there they said that since these bills were wrongly sent to the president, we under 142 hold that they've been assented to by the governor. Now let's take a case where the governor just refuses to sign, even after the bill is passed the second time. Then are the courts not, the court cannot be totally powerless to do its duty under the Constitution. 142 is sparingly used, but if the need arises to do justice between parties, and parties can be the state government and the central government fighting, why not? See, I'll just give you an example that, as you said, the governor is a very high functioning. But supposing the Tamil Nadu, the Supreme Court, instead of passing this order, had said that the governor is requested to give his assent immediately within a week or as soon as possible, and he had not signed. You can't issue contempt notices to the governor. So they said, let's do it. It's already lying for so long. Let these bills be deemed to be passed. So that is where they exercise the 142.
Right. But Justice Gupta, how challenging...
There's another question. Because
Yes.
there's another question whether 142 can be used in contradiction or in conflict with the express provision of law. It cannot. But when the law is silent, if there no timeline is given, then it can be used to say that you've not exercised your power in a reasonable time. So we are saying that you should have assented to it.
No, but what I want to understand from you, Justice Gupta, is that was it a lacuna, some kind of a lacuna that these points weren't discussed? For example, question number 14, it talks about Article 131, and it says that does Constitution bar any other jurisdiction of SC to resolve disputes between union government and state governments except by way of a suit under Article 131?
I think if anybody read 131, this question, with all due respect to the Honorable President, is not properly framed, because 131 itself starts with the words subject to the provisions of the Constitution. So if there is any other provision of the Constitution which provides a remedy, then the court has been entertaining writ petitions by the states against the central government. Now, whether that is a different issue, whether it can be done or not, I'm not going to that at this stage. But that is what has been happening. So normally, a dispute between states and states has by way of civil suits. But sometimes, like, these things are coming up where there are no facts to be proved, only things. So the court has been entertaining writs, and this has been going on for some time now. So I think this was not such an important question. The other important question which you touched upon earlier is whether it should have gone to a larger bench.
Yes.
See,
No, but,
I think that question the Attorney General did raise even before the bench. If I remember rightly, this is just I had read somewhere in the. Yeah, I
Yes.
think if I remember, Mr. Venkatraman, the attorney, had raised this question. I think he had raised this question only when this question came about extent. If it had been limited to the governor, then probably there was no need to send it to file. But as soon as you want to give direction to the president, who was not a party in that proceeding in that manner, it should have gone to the five bench. I mean, I would feel it should have gone to it would have involved interpretation of the Constitution, not the constitutionality of a law. It's not that it is the constitutionality of a law, but obviously now this advisory jurisdiction is bound to be delivered by a bench of 5 or more judges.
No, but what I fail to understand, Justice Gupta, is that why were these articles not taken up during the argument when the hearing was happening?
I'm not sure. I'm not sure, Neelu, whether they were taken up or not. And the judgment touches on some aspects, doesn't touch on some aspects. But these are important issues. The main thing is the government could have filed a review, which it may have, I'm not sure. But the review will go to the same bench, and they know their fate there. So and I don't think that this is a mala fide exercise of power. Some of the questions may not, in my opinion, be questions which really arise. But some of the questions, as I point out to you, are important questions.
But would you say that this is a smart move by the President of India? I mean, the way she's raised these questions, and obviously she must have done it in consultation with the government.
No, I think so. In fact, as I told you in the beginning, I was waiting for this to happen much earlier. I was thinking within 15 days, 10, 15 days of the judgment, somebody would move under advisory, not only for review, but also they can file a review also. But also this is because she now raising other questions also. Because this judgment does give rise to other issues also.
I remember the day when Vice President of India, Jagdeep Dhankar, had raised questions, and he had said, I think he was in a program when he said this, that how can you order a precedent? I think he was in some program where he said it, and we had done a program. Now that you are saying that it does have a legal merit, so was the Vice
No,
President?
I see. With all due respect to the Vice President, there are certain things. I mean, he talks that there's, that we don't even have a basic structure. I don't think that's right. The courts are not powerless to order the president. You see, let's give you an example. When the court orders that these women officers in the armed forces should be given permanent commission, it is an order also to the president.
Yes.
But here, as I said myself, whether a direction should be given to the president to act in a time-bound manner in 90 days in every given case is something where I agree with. I mean, it's something which I would not have done. This is one part of the judgment I don't agree with. They could have said, must act with the president or the governor, must act with alacrity as early as possible, but to give specific timelines, because that will depend on the facts of each.
No, but how will court now make amends? Will they rectify that portion of the judgment with which you are saying that you don't agree?
I can't say what the court will do. I can only give you what my opinion is. If I was there, other than touching on this aspect of the president not being bound by a particular timeline, but at the same time, the Supreme Court clearly stating that though we are not linked timelines, we do expect and hope that the president and the governor should act as soon as possible in the given circumstances of a case. They can't sit over. We are facing this not only in this. Look at what is happening in the cases of appointment of judges.
Yes.
If you like the judge, the notification is issued the next day. If you don't like the judge and the Supreme Court reiterates, there's one gentleman from Delhi High Court sitting for 5 years waiting for his appointment to come through. Saurav Kirpal. No, that's not the way governments behave.
No, but Justice Gupta, if you had been part of the constitution bench, which is going to be formed on this particular case, how would you have rectified? Because the judgment is already there now, which has been given.
So how would that you have we can't change the judgment. See, this is where I feel because as I said, this is advisory jurisdiction.
Yes.
That they will have to file a review in that very judgment. Maybe ask the review to be held on. You see, if I was advising the government, I'd say file the review petition, but tell the judges not to decide the review till this reference is decided. And once the reference is decided, then the judges, for them, this advisory jurisdiction is virtually binding. See, it's like the law of you accept what your peers, 5 of them or 7 of them say, and judges never stick to this. We have no ego of, not if we made a mistake, we are not chary of admitting that we made a mistake.
But my last question to you, sir, is that is it trickier for the courts now to make amends, or is it trickier for the union government now to explain further on all the articles and all the questions which President Murmu has put?
I don't think so. It's trickier for either party. It'll be decided as any other case. They'll be argued well from both sides. There'll be a battery of top lawyers. As I said, having gone through the judgment of Justice Pardiwala and having gone through the provisions, and especially having read the provisions again today, I do feel most of the judgment still holds good. Probably except for the giving strict timelines. But again, no, even for the governor, I would say, because the rationale will be the same. Governor, there's an additional point that question did not arise in that case. But you would still say that you were expected when the constitution, especially in respect to the governor, says as soon as possible. I read it out to you. Then the governor can't sit over the bill. Governors must act like governors. They cannot act as representatives of the government sitting in the center. They must.
So the point is that as soon as possible was already there.
Yeah, that's what I'm saying. But when they don't, no, but then it will, a state can come to the Supreme Court and say, see, it's been 3 months or 2 months or 1 month. This is an important bill. He's just sitting over it. Then the court is not.
No, but Justice Gupta, why each time come to the court? If the timelines are already fixed, then the state government might as well just act, or the governor might act.
That can be, but as I said, when our founding parents, drafted the constitution, we expected a higher level of maturity from people holding such offices. Nobody would sit back. You don't agree with it, you say you don't agree with it and send it back. If it comes back, you're bound to send. You send to it. Now what has become, it's become an ego. Everybody thinks that I am bigger than the other person.
True.
And we don't look at it as that the constitution is supreme. No, nobody else is supreme. It's the constitution. It's neither parliament, nor the court, nor the executive. It's basically the constitution which is supreme.
Right. So we'll have to wait how things unfold in the court in this particular case. But it was wonderful to listen to your insights, sir. Thank you so much for joining on the Fed.
Always a pleasure being with you. Thank you.